So no, this is my judgment.
As the court pleases.
Yes. By a complaint dated and filed on the 8th of June 2018, the claimants commence this suit and seek the following reliefs against the defendant as contained in the statement of facts. Number one, a declaration that the omission or removal of the claimants' names from the payroll of the first defendant amounted to a constructive termination of their employment without just cause. Number two, an order restoring or reinstating the names of the claimants on the payroll of the first defendant forthwith. Number C, an order directing the first defendant to pay 11 months salary arrears owed to the claimant before their names were removed from the payroll forthwith. Number D, an order directing the first defendant to pay the arrears of all withheld salaries and allowances owed to the claimant as a result of the omission of their names from the payroll. That's from February 2018 till date of reinstatement. Number E, an order of perpetual injunction restraining the defendants by themselves or through their agents or previous from tampering with the employment of the claimant except in accordance with due process. Number F, general aggravated or exemplary damages of 300 million naira for the unwarranted suffering imposed on the claimant at the rate of 1,016,000 naira per claimant. Number G, 10% post-judgment interest per annum on judgment sum, whatever it may be. Number H, any further or other order the court may deem fit to make in the circumstances of this case. Often been served with the claimants or originating processes, the second defendant filed his statement of defense on the 18th of February 2019 with leave of court granted on the 8th of July 2019, whereas the first defendant who was served with the initiating processes and several hearing notices never appeared, never entered appearance, nor filed any defense. Case of the claimants. To the claimant's case from the pleadings filed that they were civil servants in the service of the first defendant having been employed in 2011 at various grade levels. Claimant stated that the first defendant has power to employ staff in the junior cadre from level 01 to 6, while the second defendant employs senior staff from level 07 to above, including staff of the first defendant. The appointment of the claimants were confirmed after the probationary period of 2 years, and some of the claimants' appointments were upgraded from their grade levels, while others were promoted to higher grade levels. That in 2014, all local government staff in Benue State, including the claimants, were screened and verified before being captured in the database for electronic payment of salaries, and each staff was issued with a printout showing his status as a confirmed staff and his current status of employment. That they continued to work according to the terms and conditions of their employment and paid salaries and emoluments until February 2018, when their names were removed from the payroll without suspension or termination of their appointment. It is also stated by the claimant that before the removal of their names from the payroll, they are owed salaries for 11 months, and they made appeals through their solicitors to the defendant to have their names restored on the payroll, but it was to no avail. Case of the second defendant. So the defense of the second defendant is not responsible for employment of the claimants, not responsible for alleged non-payment of their salaries or removal of their names from the payroll. The letters of employment of the claimant, their confirmation and screening for verification did not emanate from the second defendant, and it did not pay salaries of the claimant, but it only approves normalization and promotion of staff to grade level 8 as its statutory responsibility over the first defendant. Second defendant, therefore, urged the court to dismiss the claims against it for non-disclosure of cause of action. Trial. At the close of pleadings, trial commenced on 24th of October 2019, while the second claimant, Daniel Ikoga, testified for himself and on behalf of the other claimants as CW1. He adopted his deposition dated 8/6/2018, where the following documents were admitted through him and marked at exhibit as follows. Number 1, 208 letters of temporary appointment, exhibit DTA1 to DTA 208. Number 2, 206 confirmation letters of appointment, exhibit DTB1 to DTB 206. Number 349 promotion letters, exhibit DT C1 to DT C49. Number 4, notification of appointment letters, exhibit DT D1 to DT D2. Number 5, 207/3 declaration of age, exhibit DT E1 to DT E207. Number 6, 200 verification screening printouts, exhibit DT F1 to DT F200. Then number 7, solicitors letters, and number 8, 2 newspaper publications for change of name, exhibit DTH1 to DTH2. Upon his cross-examination, CW1 was discharged as there was no re-examination. As there was no re-examination. On 22nd of January 2021, Andy Anure testified on behalf of the second defendant as DW2. He adopted his sworn statement dated 13th of February 2019 and was cross-examined by counsel to the claimant and discharged in the absence of re-examination. The defense was thereafter closed and the case was adjourned for adoption of final written addresses. Submission of the second defendant. Final written address filed on behalf of the second defendant dated 17th March 2020 and filed on the 19th March 2020 contains a loan issue for determination thus, and I quote, whether from the totality of evidence before the court, the claimants proved their case against the second defendant to be entitled to judgment, unquote. Learned counsel for the second defendant submitted that the evidence before the court shows conclusively that the claimants knew that they were not employed by the second defendant and were neither confirmed nor paid salaries by the second defendant, but by the first defendant. According to counsel, the CW1 admitted all these facts during cross-examination and that all documents tendered as exhibit did not emanate from the second defendant, but from the first defendant who did not file any defense to the claimant's case. Counsel submitted further that the claimant did not show any approval from the second defendant to the first defendant for their employment, or that the second defendant directed the removal of their names from the payroll. Counsel argued that the general burden is on the party who would fail if no evidence were given at either side, and such is the case of Onigbo and Onwekesin, Arase and Arase, and Akim Fosile and Ijoshe. Counsel also argued that the claimants have failed to discharge the burden of proof placed upon them in respect of the assertions they have made, hence their claim must fail. To the further argument of counsel that the 301 claimants who came to court do not have their complete documents as they have only brought before the court 208 appointment letters, 206 confirmation letters, and 200 screening printouts. That the claimants have not proved that all of them are physical persons employed by the second defendant or any other body. There's also a submission of counsel that by section 65 sub 20 of the local government law, Cap 98 revised edition, laws of Benue State, 1990, the second defendant may delegate powers to the local government to employ, dismiss, and exercise disciplinary control over grade levels 1 to 6, but such delegation must be expressed. The express delegation to employ the claimant was never given to the first defendant. Counsel therefore urged the court to dismiss the suit of the claimant in its entirety. Submissions of the claimant. For the claimant, their final written address dated 14 July 2021 and filed 10th August 2021 also contains one issue for determination to it, and I quote, whether from the totality of the evidence before the court, claimants have proved their case to be entitled to the claims sought, unquote. The submission of counsel for the claimant that the first defendant has not challenged the suit of the claimant, hence the claims are deemed admitted. Counsel cited the case of Akaji and Odeme, Central Bank of Nigeria, and Obot, Akeredulu, and Akiremi to submit that the failure of the first defendant to file a defense showed admission of the claimant's claims. Counsel also cited the case of Billy and Multilinks Limited, Gorman and Battlewin Global Services Limited. So the first submission of a counsel that is not in dispute that the first and second and third claimant were employed by the first defendant, but later normalized and promoted by the second defendant, as can be seen from the pleadings of the second defendant. that facts not disputed are deemed established. Also relied on the case of Amadi and AG Imo State. Counsel further submitted that the evidence before the court remains unchallenged as to the facts that the claimants were employed by the defendant and had their employment confirmed and enjoyed promotion. That the claimants were paid salaries from the time of their employment in 2011 until 2018. Counsel relied on Section 66 and 64 of the Local Government Law 2007. Counsel urged the court to hold that the second defendant is stopped from denying the act of the first defendant after taking further steps to regularize those acts. Counsel referred to Section 168, sub 1(2), and Section 169 of the Evidence Act. Counsel also submitted that the evidence put up by the claimant, both oral and documentary, has not been controverted or challenged by the second defendant. Hence, the claimants are entitled to judgment. Counsel, in answer to the contention by the second defendant that employment of the claimant was not courted with statutory flavor, relied on the following cases to state that the employment of the claimants was indeed statutory. The cases of Federal Medical Center, Ido Ekiti, and Olajide, Governor Ekiti State, and Akinyemi, and Section 7 of the National Constitution, which created the defendant, was also referred to in aid. That the employment of the claimants is laced with 3 statutes, and the procedure adopted by the defendant to abdicate the employment of the claimant is unknown to the Benin State Public Service Rules, and the court was urged to quash same. Counsel finally urged the court to hold that the claimants have proved their case to be entitled to all the reliefs sought. So this is my opinion.
As the court pleases.
Having carefully perused the pleadings filed by the parties, the evidence adduced, and the submissions of counsel for the parties, the issue I shall consider is, and I quote, whether by the evidence presented, the claimants are entitled to the reliefs sought. As it was earlier stated, the claimants' grievance against the defendants pertaining to their employment is that they were employed in 2011 by the first defendant and confirmed thereafter that they had been working and paid salaries until February 2018, when the defendants stopped their salaries and removed their names from the payroll without suspension or termination of their employment. It is the law that in civil claims, he who asserts bears the burden of proving that which he asserts, and the burden of proving the existence or non-existence of fact lies on the party who would fail if no evidence is adduced in his favor. These sections 131, 132, and 133 of the Evidence Act. See also the case of Lawrence and Odugbemi, Aerobel Nigeria Limited, and Fidelity Bank, Ndayako and Antoro, and Kaka and Potisco. The claimants in presenting their case have placed reliance on several exhibits to establish their claims. They have tendered exhibit DTA 1, DTA 1, DTA-B, DTC 1, DTD, and DTF to establish the respective appointment by the defendant, confirmation of same, and their promotion and verification of the said appointments. Relief 1 of assessment of fact of the claimant is for an order to declare the omission or removal of their names from the payroll for the first defendant as constructive termination without just cause. I need to observe here that the term constructive termination used by the claimant's counsel in its relief A is unfit as far as circumstances of this case is concerned. As far as I know, the concept of constructive dismissal or termination in employment law, as it was here in the case of Ms. Ebere Okweji and Standard Alliance Life Insurance, occurs when an employee resigns from his employers, when an employee resigns because his employee's behavior has become intolerable or heinous or made life difficult that the employee has no choice but to resign. And given that the resignation was not truly voluntary, it is in effect a termination. See the case of Western Excavation and Sharp. However, it can be further observed that there is no resignation from the part of the claimant in the instance case to make the court find that the resignation was a constructive one. In any event, the exhibit presented by the claimants speak for themselves, as regards the status of their employment with the defendant. Exhibit DAT1 to DTA1 to DTA208 show that the claimants show that the claimants mentioned in those exhibits were duly employed by the first defendant. And exhibit DTB indicated that they are confirmed, while exhibit DTD disclosed the approval of normalization of the employment of the first and fourth claimants by the second defendant. And again, exhibit DTC showed that some of the claimants were promoted. Similarly, the evidence and exhibit before this court revealed that the claimants were employed on 12th of July 2011 with effect from 13th July 2011 and placed on different grade levels. It's also evident that the claimants were receiving salaries and were posted to various departments of the first defendant before the abrupt cessation of their salaries in February 2018 from removal of their names from the payment vouchers. I need to mention and observe that the first defendant who was served with the process of this court and several hearing notices never appeared nor filed any defense to join issues with the claimant all through the trial. In the case of Esoho and Asuko, the court held us, and I quote, "It is the responsibility of the defendant to join issues with those aspects of the plaintiff's pleadings he disputes or consider that the plaintiff ought to establish. While the defendant declined to do so and does not join issue on such matters, the facts so pleaded will be deemed to have been admitted." Unquote.
As the court pleases.
Also, in the case of Mali and Abubakar, it was held that while the defendant fails to file a defense, judgment may be entered against the defendant in favor of the plaintiff on the basis of the averment in the settlement of claim, as such is deemed not denied. Thus, while the defendant fails to adduce evidence in denial of averment in the claimant's claims, such a defendant becomes vulnerable to the reliefs sought. See also the case of Ome and Ibe. Therefore, where evidence is given by a party and is not contradicted by the other party who has the opportunity to do so, and such evidence is not inherently incredible and does not offend any rational conclusion or state of physical things, the court should accord credibility to such evidence. See the case of Ghana, FRN. Furthermore, in the case of Osman and Abubakar, Ogoje 4 and Ogoje 4, and Leadway Assurance and Zekon Nigeria Limited, it was held that where evidence is uncontroverted and unchallenged, the court can act on same.
As the court pleases.
The second defendant has, however, contended that he did not employ the claimant and is not responsible for the payment of their salaries, and that the first defendant has no approval to employ the claimants according to the local government law. Nevertheless, the above contention appears to be contrary to exhibits DTD1 and DTD2, which are notification of normalization of appointment of the first and fourth claimant issued from the office of the second defendant and signed by one Cho Akume Ngowari Mrs., a permanent secretary from the said office. It needs to be stated that this fact was admitted by the second defendant in paragraph 4 of his statement of defense and paragraph 7 of his statement on oath, but with an explanation that the second defendant was performing his statutory duty. UW1 stated under cross-examination on 21st of January 2020 as follows, and I quote, "Once a staff has his normalization letter sent to us, we'll promote him as he becomes a confirmed staff and will not be concerned about how that person got appointed." Unquote. Instructively, the above is a confirmation that the first defendant can employ at any point in time, and the law is tried that facts which are admitted require no further proof. See the case of Ajomale and Yaduat. Exhibit DTC1 to DTC49, which are promotion letter of some of the claimants from grade level 6 to 7, also emanated from the office of the second defendant at various dates in 2014. And some of these exhibits were signed by the Director Admin and Finance, Mr. P.O. Oko, for the Chairman Local Government Service Commission, and others by the Permanent Secretary Adanu J.O. for the Chairman Local Government Service Commission. It shall be presumed and of course underscored that the above acts by the second defendant show that the employment of the claimant was regular. See the provision of section 168 and 169 of the Evidence Act, which is stated thus, and I quote, "When any judicial or official act is shown to have been done in a manner substantially regular, it is presumed that formal requisite for its validity were complied with." 169 says, "When one person has either by virtue of an existing court judgment, deed or agreement, or by his declaration, act or omission, intentionally caused or permitted another person to believe a thing to be true and to act upon such belief, neither he nor his representative shall be allowed in any proceedings between himself and such person or such person's representative in interest to deny the truth of that thing, unquote. I need to state that the defendant's attitude of confirmation of the appointment, promoting the claimants, normalization of some appointments, and payment of salaries for over 8 years would definitely put the claimants in a position to believe that they are duly employed by the defendant.
Okay.
Relief B of the statement of fact is for an order of this honorable court restoring the names of the claimant on the payroll of the first defendant, while relief C and D is to direct the first defendant to pay 11 months salary arrears also the claimant before their names were removed from the payroll, and to pay the arrears of all withheld salaries and allowances owed to the claimant as a result of the omission of their names from the payroll from February 2018 to the date of reinstatement respectively.
As the court pleases.
The claimants have in their evidence through CW1 rightly maintained that the respective employment with the defendant are valid and subsisting, as none of their appointment has been terminated or dismissed. The defendant, especially the first defendant, as it was earlier stated, did not deny the employment of the claimant, their confirmation, verification, and payment of their salaries, even though the second defendant contended that the first defendant did not have his approval to employ the claimant, thereby making the employment of the claimant irregular. However, from the state of the pleadings, in this case, the testimonies of witnesses, and the avalanche of documents presented, it is clear that the evidence of the claimants as regards their employment remains unchallenged and undisturbed.
As the court pleases.
It is the law that where an employment it is a law that where an employment relationship has been created in writing and accepted by the parties, then it creates a sanctity of contract which the court must respect and give effect to at all times. See the case of AG Rivers State and AG Akwa Ibom, while the Supreme Court held thus, and I quote, where parties have entered into a contract or agreement voluntarily, and there's nothing to show that same was obtained by fraud, mistake, deception, or misrepresentation, they are bound by the provision of the terms of the contract or agreement, unquote. It is therefore the right of the claimants to be paid their salaries monthly for the period of work done, and such right cannot just be taken away for no just cause or for a supposed lapse on the part of their employers. In the case of Ode and Federal Capital Development Authority, the Supreme Court held that a worker is entitled to wages that are earned, and this right is automatically implied in the contract of employment. Exhibit DTA 1 to DTA 208 represent the contract of employment between the claimant and the defendant with the agreement to pay salaries as reflected on each letter. The position of the law as regards the payment of salaries and wages has remained unchanged. That is, the right to receive salary or wages is determined by the letter of appointment as held in the case of Jeremiah and Idigbe. It is therefore the duty of an employer to pay wages or salary in accordance with the terms of contract, whether expressly stated or implied to the employee. In the case of Browning and Crumbling Valley Collars Limited, Greer J said an employer is under a duty to pay wages or salary to his employee while the terms of the contract say so. See also the case of Way and Latila. Once the duty to pay wages or salary exists, the employer is at common law to continue to pay such remuneration to a worker who is ready and willing to work, whether or not work is provided for the employee. See the case of Devonald and Rosa. I observed that this 7 claimants filed this case on behalf of the 295 staff of the first defendant, but as it was rightly contended by the second defendant, the claimants have only been able to present 208 employment letters, 206 confirmation letters, and 200 verification printouts. And it goes without saying that the staff who did not present to the court their employment letters, confirmation letters, and verification printouts would not be entitled to the relief sought, and I so order.
As the court pleases.
Similarly, I'm not minded to grant the reliefs for general damages, aggravated or exemplary damages of 300,000 naira as sought by the claimant. The said reliefs being within the discretion of the court is accordingly declined.
As the court pleases.
Arising from the foregoing, therefore, I'm satisfied that the claimants have been able to establish their case against the first defendant. I hereby make the following orders. Number one, an order restoring the names of the claimants on the payroll of the first or the first defendant forthwith. Number two, an order directing the first defendant to forthwith pay 11 months salary arrears or to the claimants who have their employment confirmation and verification letters before their names were removed from the payroll. Number three, first defendant is also ordered to pay to the claimants who have their employment confirmation and verification letters arrears of all their withheld salaries and allowances owed to them from February 2018 till date. Number four, an order of perpetual injunction restraining the defendant by themselves or through their agents or previous from tampering with the employment of the claimants who have their employment confirmation and verification letters before the court, except in accordance with due process.
As the court pleases.
Yes.
My Lord, we are grateful for the well-researched and concise judgments. We appreciate the industry of this honorable court, sir.
Thank you. No.
As the court pleases.
Thank you. Okay, no.
Thank you, my Lord.
I'm going to send we'll be sending the copies of the judgment to both the soft and the hard copies to you. We'll be sending them.
As the court pleases.
Okay, so that will be all for today. And
my Lord, we are grateful.
Thank you. Bye for now. Thank you.